Yeah, but that goes back to that asymmetry of risk, because you've really, if you are going to carry against statute in these areas because you believe that the statute's unconstitutional, you better be very sure that you're right and willing to face any sort of legal prosecution that could take years to exonerate you, especially because these things are in place in jurisdictions where you're probably not going to be in front of a very friendly judge. And so whereas the risk for the government officials who are making and enforcing these laws is pretty low comparatively in practice. Even maybe they should not be get the benefit of qualified immunity, but they probably will.
They probably will. And I don't think anyone's going to prosecute them for willfully violating constitutional rights. And even if they did, they'd have problems with the burden of proof. I think the one thing, though, one lesson out of all this is gun owners are making a mistake if they think that the courts are going to come in and save them from all sorts of obnoxious legislation. They might to a degree, but the amount of gun control in a jurisdiction is going to be primarily determined by the political process. Elections matter, the quality of candidates and the people that are put up matter, getting the vote out matters. Most of this is going to be decided in the electoral realm, not in the judicial branch. And so, this is just, if gun owners think they can give up on politics and litigate their way to their preferred policy, they are making a serious mistake. And there are options. No, they're not going to prosecute the officers. I mean, qualified immunity is probably going to shield them. But if gun owners win elections, there are other options. And, maybe they're never going to win enough in California. But once you start violating constitutional rights under Section 5 of the 14th Amendment, Congress can come in and enforce by appropriate legislation to stop. They can enact appropriate legislation to stop the violation of constitutional rights. And, one of the things gun owners could lobby for in a conservative Congress is to have Congress come in and say, for example, New York's licensing regime is and has always been unconstitutional. It has, it takes like $1,000 to get a license by the time you're done with training and fees. It has frequently been applied in ways that are patently unconstitutional. At various times, bribery in the process has infected the process. Even after Bruin, they enacted all these laws, many of which were declared invalidated. And once you build that record of unconstitutional conduct, much like Congress built a record of unconstitutional discrimination voting, even after the 14th and 15th Amendments were passed, then Congress has the power to enforce the constitutional rights through appropriate legislation. Congress could come in and say, New York's licensing law is not allowed. And, if New York wants to require a license to carry a gun, it can only charge $100 and it has to issue the license in 45 days. And so, there is this power of Congress under Section 5 of the 14th Amendment to override state law when state law violates constitutional rights. And this is an area that I think gun owners have not relied on. But Congress could come in here and preempt specific jurisdictions that are violating rights. But again, these and this is ultimately what happens in the voting context with the Voting Rights Act. The Supreme Court says literacy tests were not facially unconstitutional, which means that they're not unconstitutional in all their applications. Congress went back and investigated literacy tests and said, look, these are almost always used to discriminate against minorities. Therefore, they wrote in the Voting Rights Act, no literacy tests as a condition of voting. Congress could come back here and, compile a record and say, look at all the different ways that these jurisdictions are trying to infringe the right to bear arms. We are going to preempt, in these jurisdictions, these laws, and we're going to set, Congress might even be able to set the licensing policy in these states and, and do this. But this is all, desegregation ultimately did not happen because of Brown versus Board of Education. Desegregation happened when the Johnson administration threatened to cut off federal funds for schools that were still practicing segregation.
Which was a while after the Brown v. Board.
It was about 10 years after, maybe a little bit more. And so, courts are not going to implement Bruin. The political actors are. Elections matter.
Yeah.
And, that's, I think, the core message here.